Namaste, everyone. Welcome to the Cārvāka podcast. This is your host, Kushal Mehra. All right, today's discussion is called Marital Rape Laws in India. Just to give you guys a brief background. So, as you know, right now in the Delhi High Court, there are multiple pleas being heard about this subject. It's been there in the news, and there was quite a bit of discussion on the same. So, I was thinking of, basically doing a podcast that talks about the history of marital rape laws in general in India. What are the discussions about it? So, as always, I requested Nikhil to explain the legality of the issue. So, Nikhil, thanks for coming.
Hi Kushal, how are you? We've been seeing a
Ekdam
lot of
badhiya.
each other over the last couple of weeks.
Yeah, and we'll be seeing each other again in the next weekend. So, मतलब ऐसा ना हो जाए कि हमारा तलाक 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 हो जाए उसके बाद. Okay, so Nikhil, so let's start like this. पहले एक काम करते हैं क्योंकि honestly, and I'll be very I tried to read, I tried to understand what it is, but basically, what is the legal status when it comes to marital rape in India? And what is the journey? Can we start a little bit with that so that people have a fair idea about what it is all about?
No, I think it is very important to start with that because it is very easy to look at where something as at first principles distinct as a woman's right to equal ownership of property or equal inheritance and marital rape as being two completely unconnected separate things. Right? It's this is how a logical mind would at first glance think of things, but they're all connected. So I think there is first a little bit of legal history and a little bit of male shaming that needs to be done, particularly a lot of philosophical shaming that needs to be done. And once we are past that, then I will be in a position to explain where the exemption from marital rape originated and how it's developed, especially under UK law. Then I will have to come to Indian law and say what is the structure of the law of rape in India, because unlike the Indian rape statute is unlike most of any other statute in the world. It is extremely detailed and extremely well defined, uh, and often tends to try to overcome two things. One is the natural difficulty of proving rape as a charge in any kind of rape. Forget about marital rape, but in any kind of rape. And the second, the sort of policing deficiencies that we have. Right?
So, एक मिनट Nikhil, just before we get into the legality, I just wanted to share a few facts about marital rape itself. I think it's only better that I share it in the start.
Sure.
So I came across this print ka article which does a good job. So I'm just going to share the screen and read it off. So it starts with here: 1 in every 25 women in India reported being subjected to sexual violence by her husband, often or sometimes, according to the data from the National Family Health Survey 5 conducted in 2019 to 2021. Further, the
We shall
issue
carry on. I'll
appears
be right back. Huh?
Further, the issue appears to be more prevalent in some states than others, with Karnataka, Bihar, West Bengal, and Assam topping the list. In the survey, ever married women between the ages of 18 to 49 who are currently or previously married were asked about the different types of violence they faced from their spouse based on data from 26 states, data from Tamil Nadu, Arunachal Pradesh, Odisha, and union territories other than Jammu and Kashmir were unavailable on the NFHS 5 portal. Nearly 4% of women, 4% overall average, obviously different states have different variations, reported facing sexual violence often or sometimes in their marriage. However, the percentage was considerably higher in Karnataka, which is 9.7%, Bihar 7.1%, West Bengal 6.8%, and Assam 6.1%. Now this is an infographic from the print which shows the trend of sexual violence from husbands, percentage of women facing sexual violence sometimes or often. So from NFHS 4 to NHFS 5, and the worst are Goa, Karnataka, Maharashtra, Assam, Rajasthan. The best are Manipur, Tripura, Haryana, Bihar, Nagaland, where the figure seems to have gone on the other direction. Now, this is also important. Compared to data from NFHS 4, which was conducted in 1516, the percentage of women who reported sexual violence in their marriage increased to 9.7% from 6.3% in Karnataka. In contrast, for Bihar, the percentage declined from to 7.1% from 12.2%. Now, you know, again, I don't want to get into specific cases of courts itself and stuff like that, but why I read this these data points is like, a lot of times, because Nikhil raised a very important point, that we need to start with the societal angle and the philosophical argument about the subject itself. So a lot of times people will say, "Arey, kahan hota hai?" So which is why I shared this is the foremost source we can cite as far as the data and the problem itself in India is concerned. And we need to also consider one biggest factor when it comes to sexual assault, rape, and a lot of these offenses is most of the highest number of underreportage cutting across the globe happens in these sorts of cases because of the problems women face in general.
Well,
So
well, sorry, you should clarify that when you say these sorts of cases, you don't mean merely marital rape. You mean sexual assault of all sorts.
yes, yeah, all sorts: sexual assault, marital rape, eve teasing, many other cases. A lot of time women don't report it. Another shocking incident that I found out was that the highest amount of assault on women actually happens from the immediate family circle, which was the most depressing point in this entire thing when I was reading up on it. Now that I've laid out this, now Nikhil, I give it back to you.
Right. So, rape is as old as time. And so, therefore, what we have to look at is why has it forever and ever in every single jurisdiction in the world been such a difficult crime to prosecute? And what were the theories that actually made it almost immune from prosecution for prolonged periods of human history? Right. So, there is a little bit of feminist theory that I'd like to highlight here. And their proposition is that women have been subjugated to male desires and wishes since the dawn of the species. Because of nature's design of the female and male bodies, woman was forced by nature to accept man as the protector and the subjugator, and thus women became dependent on man after centuries of domestication by protective mating. And this is really what this sort of goes to is one is the species need to perpetuate. Second is the hostility of the environment that that humanity sort of arose in. Think of cavemen, so on and so forth. Uh, and this established a natural sort of subordination role where there was no scope in the way society was developing for that subordination to be breached and broken. Or at least we don't get much evidence of it. That is not to say, and I should not be heard to say, that female cavemen couldn't have handled, tigers and lions better or couldn't have handled them as well. But they were just simply never considered in the position because they are the vessel that is the child carrier. And therefore, in a sense, much more important to protect. Because without them, the species will not survive. You can imagine what life expectancy at that time would have been. You go hunting in the morning, some come back, some don't come back. Right? As simple as that. So this was how the sort of initial dominion of men over women existed and was created. Over time, as humans began to band together into protective communities, the societal view of women as chattel predominated. And this is very important. The looking of the regarding of women as property. Right? And if someone physically harmed a man's wife or daughter, he had effectively committed a crime against the male estate. So, what you are seeing now is the conversion of a human being into pure chattel. We talk of slavery, we talk of so many other crimes that either expressly do this or attempt to do this, but the male female relationship has always sought to do this. This was really the philosophical basis of almost all law. And I know this will be shocking to a lot of people, but this is actually the truth. This is how it sort of originated and developed. And you can have, and this is not, it is not as if there are exceptions on this philosophy in different countries or in different cultures. This is fairly unanimous, right? Now, so much so that early Roman law and Roman law in general, and the Roman Empire in general, is a major inspiration for English law and the English colonial empire that came thereafter, right? In early Roman law, the concept of property, women as chattel, had progressed so far that they had a singular offense called raptus. And raptus was the taking of property. It didn't matter whether it was actual physical property or a woman. So there was that parity. And you will find that in these older legal systems, and in fact, all pretty much through parts of medieval times as well, till actually fairly late in certain jurisdictions, till the 18th century or so, there was very little distinction between the law of abduction and the law of rape. That abduction that is the taking of property. Abduction and was the main offense, and rape was merely a consequence of the abduction.
That's so disgusting.
It is. So this is why, it is important to shock people with these are the underlying theories, right? It is important that people understand when you defend certain things, what values you are defending. Now, as this progressed, we develop marriage rituals, right? And if you look at the marriage rituals of almost any religion, of almost any society, any culture, uh, there is the concept of giving up your own body, right? So in Christianity, the wife promises in her marriage to honor and obey her husband. This comes from the concept of chattel. Forsaking all others to keep only unto him as long as both shall live. These are actual vows from the Bible.
Hmm.
Other cultures have required a dowry, which ensured that new husband would have adequate wealth to care for his new property. The concept of dower and dowry comes from here as well. So this is the root point, right? Under Roman law, the woman's father would provide goods for the new husband and wife, which was known as the dos. All that property which on marriage is transferable by the wife herself or by another to the husband, with a view of diminishing the burden which marriage will entail upon him. And this is the subsequent medieval concept of the bride price. This is the concept of dowry, right? It is not merely, there are modern reductions of these things because you see an otherwise equalized society, so you are able to reduce these heinous ideas to say, oh, this is only a gift, oh, this is only to allow the new couple to move forward together. The root concept was that you have now taken on a burden, and that burden didn't exist prior, and I am losing a burden, right? As the father, I certainly don't have this burden. So I must pay to you something so that you can discharge the burden that I am placing upon you. I mean, I like how disturbed you're looking. This is going to go on for a bit.
This
The
is
concept
actually
of
very,
bride,
very depressing.
it is depressing. The concept of bride price was meant to ensure that new husband was actually buying the person and services of a virginal wife who was chaste and free from disease.
Oh
Right?
my God.
And as you would then imagine, as with any set of goods, there are high value goods and there are low value goods. And virginal goods, in the case of a wife, are high value goods. And therefore, the value in bride price for them was higher as compared to others who may be non virginal and therefore regarded as unchaste, or who had at any point in time been driven into slavery and therefore lost their virginity. The bride price for them was low. Right? Often the unchasteness of the woman was a result of rape, but this typically did not diminish the societal view that she had somehow conspired with the man in the loss of her chastity by rape. When you look at women as chattel, and when you look at them as only property, and you look at virginity or virtue as only a weighing measure for this evaluation, then you generally regard that the property itself as somehow colluded. Because this is a rare form of property that has intention, that is a human being, that has intention, that has capacity to collude, that has capacity to join. So this is really, underlying theory. Now, as with all bad ideas, Kushal,
Hmm.
once they take root and they are for the benefit of one superior group, when the opposition starts coming to these ideas, they start evolving.
Hmm.
Chameleonizing is what I would call them, right? It's the same thing that kind of becomes a little bit more different and then a little bit more different, but is essentially just a new word of ideas, a new word salad that is trying to protect at the core the same earlier concept,
Hmm.
right? So, three important legal fictions existed at common law at different points in time. And common law, just to be clear about this, the Indian system is a common law system. A lot of our lawmaking is common law lawmaking. And the common law in its purest form was that law would be all judge-made law, not parliamentary law, right? And that judges would determine through cases that have already been argued by parties what the law would be. And therefore jury system became important because you did not want just one judge determining all of this. You wanted juries to be able to state the societal view on this as well. So the case
Hmm.
law becomes the source of the law. After Parliament became a more prominent entity in the 14th, 15th century, parliamentary law usurped the sovereign power of lawmaking from the courts. But the courts still retain that they are the ones who are going to declare the law. You will pass the law, but the courts declare the law. That is, they interpret the law. And their interpretation is binding on future cases. That really, in a nutshell, definition is the common law, right? So in common law, judges are evolving these theories because in the UK, and this will be shocking to a lot of people, sexual offences weren't actually legislated till 1976, whereas they had done legislation of sexual offences in the Indian Penal Code as early as the 1870s, 1880s, with
Hmm.
subsequent modifications as well, right? We were an experiment for them in certain respects. And this is, by the way, one of the arguments of the colonialists raised, that things that were progressive that we were not doing unto ourselves in the UK, we were doing for you. So the
Hmm.
first theory is what I've somewhat elucidated on already, which is the woman is chattel theory, that a woman was the first property of her father and on marriage became the property of her husband. In case somebody is curious, I'm actually reading from notes that I've made from various sources in preparation for this. Uh, and this was the disturbing sort of corollary, and a natural corollary. It doesn't need much imagination to understand this corollary. Is that if a woman was merely property, she had no individual human rights, right?
Hmm.
And the husband who perpetuated uh, rape on his wife was merely using his property in a manner he saw fit.
Hmm.
Let that sink in. Now, this is, of course, so appalling in terms of a moral position and in
Yeah, I don't
terms
have
of.
words.
Yeah. So, but let me be clear about this. I am not reading to you things that are outside of actual justifications given throughout the development of the law.
Hmm.
These are not points of analyses that I am raising. These are actual descriptions in legal documentation at
Yeah.
times, right? Now, this women as chattel theory now modifies itself into something called coverture. Uh, by definition, it meant that the condition or state of a married woman, the legal disability that formerly existed at common law, whereby the wife could not own property free from the husband's claim or control. Being thus legally disabled, the wife had no recognizable legal rights independent of those shared with her husband. An offshoot of the coverture ideas was the unities theory that will come later. But now, at least, what you've gone and said is that now she has rights, but those rights originate from the husband, right? So now you can have some ownership of property, and this is why I said taking the idea of inheritance on one side and marital rape on the other side might seem completely disparate, but they're actually connected because one does until one develops, the opposition to the other doesn't come, right? So the
Hmm.
coverture theory now allows, and what it says is that women can obtain property rights. That disability of the chattel theory is gone because property cannot own property.
Hmm.
So women, when they were regarded only in legal theory as only chattel, they could not own property. But now the Cārvāka theory says, all right, this is a human right that we confer upon you. We recognize your humanity. But the source of your right will come from your husband.
Okay.
And this is when women are still not allowed to inherit anything from the parental side. Everything goes to the son. Right?
I was reading a beautiful 1975 paper about the Hindu Code Bill dealing with all these things. Different laws at different times. It's and the
This is very
rejections.
material, and I would urge you later on in this podcast to describe this paper, because what I'm going to try and say is that my final thematic argument here is that if every single element and every single element and every single ingredient of what constituted the logical basis for an exemption from marital rape has fallen apart, then marital rape itself must fall apart. That is why I'm taking the long route, starting from this point here and going downwards. Right? So the unityist theory was that upon marriage, they became one entity. And that entity is not a new entity. It is not a third entity. In our modern legal systems today, your marital harmony is a third entity. Therefore, there are joint ownerships. Right?
Yes.
Which can be passed into individual ownerships. So one example of your joint entity creating a third entity is, for example, no problems of taxation, no problems of benami, etc. when you're transferring from husband to wife. Unity, but independent status as well. Right? That independent status is not unity, and the surviving entity is the husband.
तो मतलब हस्बैंड के अतिरिक्त कुछ नहीं.
No, you are something, but then there should be no husband. But once there's a husband, you are the husband.
This is so stupid.
So this is the thing. I mean, you look at how rapid scientific development has been in the last 150 years, right? Compared to the preceding 10,000 years or more. The last 150, 200 years has been so rapid. But we also got rid of thoughts like these over that time period. They go hand in hand, all of this kind of development. Now, if you will recall, when we had done a podcast on free speech, I'd introduced to you a gentleman by the name of William Blackstone. And William Blackstone had established the first statement of what amounts to free speech as a legal principle, a statement that America had accepted and the UK had accepted, right? And it still to date remains the broadest enunciation of free speech. That is William Blackstone speaking for men. Okay, that is William Blackstone speaking for men and their rights, and how expansive he views their position and their rights. Now, let me tell you William Blackstone speaking in the context of women. In his commentaries, the very same commentaries in which he also spoke of the right to free speech, which I had cited to in our previous podcast, in the same book, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into her husband. The idea behind the unityist theory was to inspire and perpetuate marital harmony. With only one person in the household who could give orders, there could be no confusion as to the identity of the master. So long as the marriage relation continues, the law allows but one will between them, which is placed in the husband as the fittest and ablest to provide and govern the family.
Yes, shabash.
Matlab, when he's talking about men, what a broad libertarian, what a thinker, right? And suddenly when he's talking about women, you could not be, how much more aggressive can you be? I mean, you can try harder, I'm sure, but this is pretty much the bottom line right here.
What is scary is ये इतने साल पुराना भी नहीं है.
Yeah, it's not that old. It's 19th century. Some of it is early 20th century.
Yeah, that's the scary bit.
No, no, and then the scariest bit to this is the underlying statement of law that established in common law the basis of marital rape is from 1736 and went almost unchallenged all the way to 1954 or so, from which time some small exceptions started to get carved out and didn't disappear in the UK till 91. Take a progressive country like Finland. Finland had the law of marital rape as an exception to rape till 1994. So we really, it's not that old, all of this. And I'll explain why societies struggle, why they struggle with these exceptions. But anyway, and I want to read the kind of once the issue started to develop, right, in the 20th century in particular,
Mhm.
there were a lot of people coming forward and saying this marital rape exemption is rubbish. Just for a second, Kushal, because in case people are confused as to what the exemption itself is,
Hmm.
can you just pull up 375 for a moment?
Sure, I'll do it. I'll pull it up immediately. Section 375 of the IPC. There you go. It's on the screen.
Right. Can you come to exception 2? It'll be after,
Okay.
you see, firstly, fifthly, sixthly, seventhly.
This is sixthly, and then exception it comes over here.
हाँ, exception 1, exception 2 लेना.
एक्सेंचर 2 नहीं है इधर, मैंने जो खोला हुआ है इसमें
हाँ,
फर्स्ट
I
है
know, I
अगेंस्ट.
know, I know where you are. I know. I'll keep going. You've gone
हाँ,
to
बी.
exception 2 to the proviso. Anyway, I'll read it out. नीचे चलो. Is it just
नीचे
one
नहीं है,
page?
इतना ही है. इतना ही है बता रहा है. आई गेस जो मैंने खोला है वो पूरा नहीं है.
Yeah, you haven't got the full one. Chalo, doesn't matter.
ओके.
What it reads is sexual intercourse or sexual acts by a man with his own wife, the wife not being under the age of 15, is not rape.
व्हाट?
Yes, that is the exception. Right? And
But how can that be so? That's so ridiculous.
right. No. I'm just explaining what it is. This was the exception. Just keep it in mind. Just keep it in mind. Right? You can remove this.
ओके, एक मिनट नहीं. आई थिंक.
What I'll do is I will get you a proper section 375 and forward it to you, and you can then.
Yeah, this is. My brain cells are hurting. मतलब लोग, ये हमारे कानूनों में लिखा गया था.
Huh.
This is unbelievable. I'm just trying to digest it as we go live, so people know, like, this is the thing when you do some things live. I mean, sometimes you just can't digest them, and this is one of those moments. मैं तो बैठ के कानून पढ़ता नहीं हूँ, तो I am just reacting as I watch it happen, and this is messed up, to say the least. Oh my god. There were human beings actually writing this stuff.
Yeah. I mean, I'm telling you why they were writing it as well, right?
Oh, so you're talking about that with a women under 16 years of age with or without consent. That was exceptions to 370. I got it. I'll pull it out. I'll pull it out. Now I got
No.
it.
I'm
I got
sending
it.
it to you again on
ये
your
देखिए,
Cārvāka
मिल
podcast.
गया. Exceptions to 375, exception 2. When
No,
there
but
is sexual
not a narrower one. It's a state amendment. I want the full one. I've just sent it to you again.
Okay, ठीक है. तूने WhatsApp किया कि email किया?
On your Cārvāka podcast email.
Okay, I'll open up my email. Cool. दिमाग खराब हो गया मेरा ये पढ़ के. All right. Okay. Apologies to the people who are watching this live, but it is what it is. we have to share the screen because. All right.
Right. So as of now, I'm not going to go down. I don't require more of this, but I'm going to come back to what I was saying earlier.
So this highlighted bit is the section 2 that you just read out
Yeah.
on the
Yeah.
screen.
Yeah. Okay. So you can move away from this now. It's
Mhm.
not material to what I'm going to do now.
Okay.
Now I'm going to read certain justifications for the law of rape. I found these paragraphs very, very interesting. Right. I found these paragraphs interesting because a lot of the argument even today that we are hearing before the Honorable Delhi High Court is not dissimilar to some of these justifications against the law of marital rape. Right? Nobody today, let me be crystal clear about this, and this is in fairness to everyone who is arguing the case before the High Court. I don't think anybody, even the men's rights forums, have taken the position that there simply cannot be a law of marital rape. They have taken the position there can, but this has to be left to Parliament for Parliament to determine how it is to be done properly. And I
Mhm.
have some small amount of empathy for that position because of the legal structure of the law of rape in India. And
Hmm.
we'll have to explain that. Right? And obviously also the supervening problem, because you have to present both sides, that consent operates very differently in marriage versus in a non-marital situation,
Hmm.
right? The giving or not giving of consent is a much more difficult concept in both these different situations. Anyway, leave that be. So there have been several justifications offered for recognizing a marital rape exemption. Among the fears of jurists was that if rape were recognized as a crime that men could perpetuate on their wives, the women would fabricate rape charges against their husband and use these charges for some kind of revenge. Right? And the problem is that the law 498A in India, the law of domestic violence in India, courts have repeatedly said that these are trumped up fabricated charges coming up repeatedly. So under the
Mhm.
law of cruelty, under the best possible intentions, 498A was drafted in, right? And the idea was that since dowry and dowry death was such a massive problem, that if an allegation so much of dowry arose, arrest was automatic.
Mhm.
It was automatic.
Hmm.
And then
That
you
was
had
a
the
draconian law, basically.
so you call that draconian, but the societal problem was far more draconian, right? So until that fear came in, what could
I
you do?
agree with you, but I'm just trying to give the
There are no good
argument that
solutions to these
I've heard
things.
many
The
times.
problem you get stuck with. There are no good solutions to these things. Anyway,
Hmm.
about 15, 16 years of experience later, the Supreme Court itself said the preponderance of fake cases is just too much.
Hmm.
And I don't just, this is very conveniently just blamed on women. I'm sorry, lawyers are at the heart of this. Lawyers are the ones who go and say, please file this complaint in this way as I am telling you because this will be to your benefit.
Hmm.
Right? Anyway, so that's the first one. The next is the fear existed that recognizing crimes within marriage would permit state intrusion into the privacy of the marriage, thus prohibiting the man and wife from reconciling the problems on their own. Right? So, in any event, these are justifications that existed at the time at which a very famous concept used to exist in Indian in common law, and common law applies in India, in US, and many other countries, all Commonwealth countries, right? Which was the law will stop at the bedroom door. But what it did not restrain was a heinous concept called the restitution of conjugal rights. If a woman ran
Okay.
away from her husband, right, and did not wish to reside with him, he could file a petition effectively in the nature of habeas corpus, saying, put her back in my own house. Put her back in my bed. That's the theory. Let me not even be polite about this. Put her back in my bed. Conjugal rights. Restitution of conjugal rights. This would be decreed. So against your will, you'd be brought back into that home and into his bed. Now you have no marital rape. You have a marital rape exemption. So you're going to suffer all kinds of heinous domestic violence and sexual assault. And the law stands with some archaic theory or the other saying none of this is any kind of offense whatsoever.
Hmm.
In fact, we will be party through a restitution of conjugal proceedings order or a decree, we will be party to whatever sexual assault that you commit because we will facilitate it by bringing her back. Right?
Hmm.
And of course, the famous one, the exemption was also justified on the grounds of marital rape was simply not as serious as other types of rape. And that wives were adequately protected by other legal ideas, such as assault statutes, which typically provide less severe penalties. This argument, in a much more sophisticated form, is being raised even today in the proceedings before the Delhi High Court. That because
Okay.
law of cruelty exists, law of domestic violence exists, there are enough remedies to protect women, and a charge against rape, a charge of rape needn't be brought. Right?
In
And the
fact,
counter
that was
argument,
something that I was going to ask, that when we frame laws, isn't the most important and most effective point that when we frame laws is that do we need the law, or do we need an amendment, or do we need a completely separate new regulation itself, right?
so these are all questions that have been raised. One of the biggest stumbling blocks for the petitioners in this case, by the petitioners I mean people who want to propound the position that marital rape cannot be exempted, is that in effect what you're asking a court to do is to legislate a fresh offense.
Hmm.
And that power should only lie with Parliament. Right? I'm going to now deal with how this law develops in England, because how it develops in England is eventually the basis on which it develops in a lot of common law countries. But there still remain, including us, 36 countries in the world in which law of marital rape doesn't exist. I mean, in the sense that the immunity to rape in marriages exists. Right?
Hmm.
So, there is, in the 20th century, with the suffragette movement,
Hmm.
and therefore the accordance of voting rights, equal voting rights to women, the evolution of property rights, where inheritance can now be made in the favor of a daughter. And really, all it is, or to say these things are great, grand conceptions that arise out of nothing, it's not necessarily true. There were a lot of rich English heiresses who had entered into society. They had become editors, they had become publishers, they had become journalists. They were writing more about all of this. I mean, I say this a little flippantly, but I'm sure a lot of your viewers have seen Downton Abbey. And one of the daughters in Downton Abbey, to the total uh, aghast and appall of the dowager, she's called the dowager because she brings the dowry. Uh,
Hmm.
she becomes an editor of an English broadsheet in London. Right. So this is when women's issues start coming forward. When they start coming forward, now what happens is that the law also starts to develop. So in the UK in 1949, in 1954, 1958, two or three judgments arise that say, look, if you have had either a legal separation or a judicial separation, right, you have broken that old unities theory. And if in that period of judicial separation, the man were to commit rape, that cannot be exempted anymore.
Hmm.
Right? So at least some. Now, bear in mind that judicial separation is not the same as divorce. So
As
even
in?
if a judicial separation is the decree saying that we wish to live apart, right? But you're still married. So it is still within the context of marriage, and therefore it is regarded as an exemption to marital rape at that point in time. But those judgments were still stuck on technicalities. They were still saying when you say judicial separation, it should be judicial separation as recognized by law. That is, there should be a decree behind it saying you are judicially separated, or an agreement between the parties that you are legally separated. Merely living apart would not suffice. Okay. And then 1976 comes, and 1976 they finally legislate sexual offenses. And the definition of rape, though, has one very tricky word. The definition of rape uses the word unlawful sexual act. When you use the word unlawful sexual act, you get the feeling that the definition itself is creating the exemption of marital rape. Because sex within a marriage is lawful.
Hmm.
Right? This is how one side interpreted it. And it posed problems for the courts going forward. But be that as it may, 1990, a law commission report is issued in the UK, and it still does not legislate, it still does not advise that marital rape exemption should be granted. And it's still, sorry, the marital rape, it still perpetuates the marital rape exemption. But three cases arise in 1991. And all three cases eventually reach the House of Lords. But three separate cases, and the first and most famous, and this is the header case, that eventually became the header of the House of Lords cases. R versus R, Regina versus Regina, because the names of both parties were excluded. The wife had left her husband and moved in with her parents. The husband told his wife on the telephone that he was going to see about a divorce and then broke into her parents' home and raped her. The trial judge found that the wife could unilaterally withdraw her consent to sexual relations with her husband by withdrawing from cohabitation and thus clearly indicating her withdrawal of the implied consent. So this is more development of the law. Bear in mind, I told you earlier, just now, that judicial separation was a basis of breaking this marital code, right? But judicial separation requires formal legal steps. Now a trial judge is holding, I don't need formal legal steps. Once you've breached cohabitation, broken cohabitation, then there is enough indication to the man that consent has been withdrawn. Right? This is still the trial judge. So the trial judge holds that the marital rape exemption will not apply. The judge left the factual issue of rape to the jury, but the husband pleaded guilty before trial. He didn't want judgment on this. Justice Owen found that in this situation where the wife had moved out and the husband telephoned to discuss getting a divorce, unilateral actions of each of the parties clearly led to a mutual understanding from which the wife's non-consent could be implied. Right? This was an expansion of the previous case law doctrine, as here the actions of the parties alone was sufficient to establish the wife's lack of consent. No further judicial actions were needed to make the arrangement binding. Like I said, you didn't need a decree of judicial separation. And then came R versus C, where again something similar had happened, and the judge wrote, "Happily, perhaps my ruling matters substantially less in this case than many others, noting that other charges that the defendant faced were equally serious as rape. Therefore, his decision regarding whether the exemption still existed in English law would not materially affect his accused's eventual fate. He found, however, that the position in law today is, as already declared in Scotland, that there is no marital exemption to the law of rape. That is the ruling I gave." So he gives an express ruling that there is no exemption to the law of rape, marital exemption to the law of rape. Scotland had already done this in the mid-80s and done it with an excellent resounding judgment saying this simply cannot be. Right? And then comes R versus J. And R versus J is the first judgment and creates the opposite judgment. This is the judgment that goes and says that word unlawful in the 1976 enactment of sexual offenses. That creates a problem to any judge holding that marital rape does not exist. That marital rape exemption has now been removed in common law. A judge cannot say this now that the statute is passed. Remember, when I was explaining common law, I was saying that judges develop the law. But when it comes to statute being passed, statute is the law. You are merely interpreting it and declaring it. So once the statute comes and says only unlawful sexual acts would amount to rape, the word unlawful would create a problem. And I'll quote from it. He looks at the R versus C, where Justice Simon Brown had said that I am clear that there is no marital rape exemption. And this is what he says in relation. He was prepared boldly to cut the Gordian knot and to hold up the statement of the law of Scotland as appears in the record of S versus HM in 1989 should apply to England too. In other words, to sweep away an out of date rule and declare the marital exemption no longer existed. If I felt free to do so, I should certainly follow this eminent sensible line. To anyone accustomed to the late 20th century equality of the sexes, it must be totally repugnant that a wife is deemed by no more than what is a fiction to consent to submit to her husband's demands for sexual intercourse, whatever the circumstances. It is true that there is a danger that the abrogation of the rule might lead to a spate of false claims from spiteful or disgruntled wives, but I consider this is something which the trial process will have to deal. But the intervention of the statute has precluded any up-to-date declaration of the state of common law on this subject. The matter has now become one of statutory interpretation and remains so. It seems to me that if Hale CJ's rule is to be declared no longer law, it is for Parliament alone to declare it. I only express the hope that this case may play a small part in advancing such a declaration. So that word unlawful did to him. Now, what does he say? He says there's a legal fiction at the heart of the marital rape exemption. And what is this legal? It's called the Hale's law, Hale's rule.
Okay.
There was in 1736, an English jurist, may have been a Chief Justice, Sir Matthew Hale, had stated, the husband cannot be guilty of a rape committed by himself upon his lawful wife, for by their mutual matrimonial consent and contract, the wife hath given herself up in this kind unto her husband, which she cannot retract. And similarly, in 1803, a husband cannot be guilty by ravishing his wife on account of the matrimonial consent which she cannot retract. So this is one of the issues that keeps arising. Does matrimony amount to open consent? Right? This is a layer.
No.
Sorry?
Obviously, no.
I know what you're saying. Now, I'm going to come back to those judgments that I was reading. Now, the Court of Appeal sided with the idea that because statute is passed by Parliament and the word unlawful is used, now judges can't alter this. This has to now be altered by Parliament only. And this is an argument being raised today before the Delhi High Court. So I am giving to you in what will seem an odd way the arguments of the Delhi High Court through the history of English law, because they're all reappearing. There are no good new arguments. There is no good new argument, right? These are the same arguments.
बेसिकली ये एक यूनिवर्सल इशू है, क्योंकि आप अगर रिलीजियस टेक्स्ट को भी पढ़ोगे तो मेरा जो भले वो याज्ञवल्क्य की स्मृति था या मनुस्मृति थी या बिब्लिकल कैनन्स थे या कुरानिक हदीस थी, जब मैं पढ़ रहा था इस इशू के ऊपर तो कंसेप्चुअल मूवमेंट वही रही है. विमेन आर चैटल से प्रोग्रेस होके अभी प्रॉपर्टी एंड कमोडिफिकेशन पे आए हैं कुछ जगहों पे, ऐसा हो रहा है.
हाँ, बिल्कुल. So now the problem that they had was if they accepted this broad definition of the word unlawful under the Act, you had over 100 years of common law history that was creating exceptions to the law of marital rape. All of that would get erased in one go. Right? So that they thought was this is not going to work. I mean, we can't accept an interpretation that erases everything in one go. So there was a second alternative, which was called the compromise solution, and that said that the word unlawful ought to be construed to allow all of the exemptions that had been established in modern times to still apply in marital rape cases. To draw back to this idea that it would permit additional exceptions to be identified in the future. The court felt that this would eventually lead to similar problems of definitions and interpretation in the future, and thus lead to instability in domestic relations law. And the third concept was the radical stance, the radical solution. And this was stated thus: Hale's proposition is based on a fiction. It took us a long time of human development, Kushal. And Hale makes his declaration in 1736, where it takes us all the way to 1991. Somebody to turn around and say, Hale's position is based on a fiction, and moreover a fiction which is inconsistent with the proper relationship between husband and wife today. Why do I say today? Why was this emphasis added? Because we are seeing that in every other material aspect of life, the rights of women have become equal to men. Yeah. Right? And this is the sad part. This was by conferral. This was It was a long process of conferral by which this happened. Now, when those rights have become equal, how can you hold any of these old fictions and theories to still apply? For the reasons expressed in the Scottish judgment, it is repugnant and illogical in that it permits a husband to be punished for treating his wife with violence in the course of rape, but not for the rape itself, which is an aggravated and vicious form of violence. So, if you were to commit an act of battery upon the wife, to hit her, render her unconscious, and then force yourself upon her, you can be charged for the act of violence, which was the battery, but not for the rape itself, which is a much more vicious form of violence. These absurdities need to go. But the court accepted something which is going to be a fact and issue, major point of issue in our proceedings in the Delhi High Court as well. The court noted that in choosing the third option, it might be trampling on the realm of Parliament. And understand this, in the UK, courts defer to Parliament, generally defer to Parliament, much more than our courts do here. For them, this was radical. However, because the world had changed so drastically since the time that Hale first stated the exemption, the idea had become a mere legal fiction. Therefore, the court held that a rapist remains a rapist subject to the criminal law, irrespective of his relationship with the victim. This is not the creation of a new offense. Please mark this. This is very important because this is one of the principal objections arising from one of the judges on the bench and from those opposing is simpliciter striking down of that exception too. This is not the creation of a new offense. It is the removal of a common law fiction which has become anachronistic and offensive, and we consider that it is our duty, having reached that conclusion, to act upon it. Now, what is the difference between this and us? Hale gives you a legal fiction that is in a judgment. Parliament gives you an act. The UK Parliament gives you an act where it uses the word unlawful sex, but that is only an interpretative issue of whether it exempts marital rape or not. Indian Parliament gives you a specific marital rape exemption.
Shabash.
Correct? If it gives a specific marital rape exemption, how can a parliament, so therefore the question is validly raised in the Delhi High Court judgment, in Delhi High Court proceedings, that if the exception exists, to legislate out of to remove this exception is now an act of legislation. And therefore, this discussion in R versus R in the UK stands on a slightly different footing than our case today. Okay. What makes the tension between the previous marital rape case decision and that of Owen of the House of Lords even more interesting is the consideration of ex post facto laws. Now, this particular objection that the House of Lords effectively created a new crime, this was taken up by the husband to the European Court of Human Rights. Okay. Despite the fact that the House of Lords opinion specifically cited the Criminal Appeals Court wording that this did not create a new crime, the husband appealed this to the European Court of Human Rights, claiming a violation of Article 7(1) of the Convention. That court found inter alia that a common law court could exercise their customary role of developing the law through cases. Remember, I told you that they developed the law through cases, so long as the changes in the law were reasonably foreseeable. Here, the court reasoned that the underlying law already explicitly contained the exceptions to the general rule. Further, as the underlying crime of rape was sufficiently defined in the law, it was possible for the defendant to have sufficient knowledge to know that this act of raping his wife constituted a crime. But that is because their statute did not have something similar to Exception 2 in India.
Exception 2, just to remind everyone, of Section 375 of IPC.
Yeah. Now, I was thinking we will go to the Indian law.
Yes.
You have seen the history. You have seen a lot of the arguments that are going to be repetitively raised. I'll present them in terms 14, 21, etc. Privacy, etc. as they're being raised in the court. And what the rebuttals are. And what the center's position is. Right? So I think now if you can pull up that 375.
375 वापस ना? Okay.
हाँ.
Okay. एक मिनट रुक. हाँ जी, 375 on the screen.
First and foremost, please note a man is set to commit rape. In the Verma committee, of which I was a part, our recommendation had been that there should be a gender neutral provision. But
yeah, because in the case of lesbians and gay people, फिर उनका rape ही नहीं recognize होएगा ना?
That's the problem. That's the problem. So I think there will eventually be, but that equality argument is going to get raised eventually. So it's not a problem so much. But anyway, be that as it may.
ये भी हमारे देश में मतलब अजीब किस्म के स्यापे हैं.
No, it's not, because it does recognize that the overarching reality is that of patriarchy. So you can say that theoretically the offense can arise from different circumstances, but really it is a man-on-woman crime.
No, I get the overwhelming evidence, but the job of the law cannot be to just look at the overwhelming evidence of one side. See, every society anthropologically has 2 to 5% lesbians
not
and gay
looking at
people.
overwhelming
So
evidence. They're looking at the overwhelming number of cases, right? But I agree with you that the concept is that of deprivation of consent in the act of in a sexual act that should apply to one and all. Anyway,
and even in a heterosexual marriage, what if a man is raped by a woman? I mean, even if it is the rarest of rare cases, but the law should be built on the premise of equality and uniformity, right?
So
गजब दुनिया है हमारे देश में.
So I'm going to read a bit of this. A man is said to commit rape if he penetrates his penis to any extent into the vagina, mouth, urethra, or anus of a woman, or makes her do so with him or any other person. Right? A number of these were added in. It used to be a much narrower definition by the Verma Committee, by recommendations made by the Verma Committee, which Parliament then accepted. A man is said to commit rape if he inserts to any extent any object or part of the body, not being the penis, into the vagina, the urethra, or anus of a woman, or makes her. And this is very important, because this means you can commit rape with your fingers, you can commit rape with your digits. And this is the allegation against Tarun Tejpal.
Gosh. Just
right. And and clause C then deals with clause D then deals with oral sex as a form of rape. Now come to under the circumstances falling under any of the following 7 descriptions. If you do these acts in the following circumstances, it amounts to rape. Firstly, against her will. Secondly, without her consent. So there's a distinction between will and consent.
जी मगर ये तो फिर क्लियर कट केस हो गया ना कि मैरिटल रेप रिकॉग्नाइज करना चाहिए.
That's what I'm trying to get at slowly, right? Against her will, without her consent are 2 separate circumstances. So therefore, will and consent are separately understood and separately defined. The interesting thing I found is that under UK law, also will and consent are separate, but the UK law completely discards the concept of will, because they look at against her will being only a form of forceful rape. Only if force is used is a will overridden, whereas consent can be overridden even in a normal circumstance. They look at it that way. In Indian law, we say will is a state of mind, consent is the statement of that state of mind. So you may be, if you're silent, it is still against your will, even if your consent has not been conveyed, or the absence of your consent has not been conveyed. Right? But there's something very important in the way this is drafted. Against her will, without her consent. It is not drafted in the positive sense of where she openly consents. It is without her consent.
Got it.
So therefore, the man as a rapist must have the state of mind that he knows that she is not consenting. right? And because of that, a lot of rape prosecutions fail. So he says, because of our circumstances, I assume consent. And they fail also because of something that you had brought up earlier on in this podcast, which was that a lot of rape occurs between family members within or people within the within or amongst a group that the woman intimately knows, personally knows.
Yeah, एक मेरा question है. You know, the biggest problem with something like this is every time the question of evidence comes, the evidence, how do you get the evidence? In fact, one of the weird arguments that comes like, how do you rely on, like, do you go on forensics? And you know, with marital rape the argument is कि क्या अभी कैमरा रख के रूम में रखेंगे? तो भाई कैमरा रख के
That's it.
नॉर्मल
And
रेप में कैमरा
you're
रख के
getting
होता
to
है
the
क्या?
you're getting to a major part of the point. Why I'm reading this is actually I'm just laying out some basics so that people understand the law of rape. This is a good opportunity to understand, at least at a prima facie level, the law of rape. But Indian statute has a lot of modulators, I call them, where how the consent is to be conveyed, whether consent is to be proved, not proved, stands modified. Okay. Anyway, let me proceed. Thirdly, with her consent, when her consent has been obtained by putting her or any person in whom she is interested in fear of death or of hurt. So this is a coerced consent. Fourthly, with her consent, when the man knows that he is not her husband and that her consent is given because she believes that he is another man to whom she is or believes herself to be lawfully married. A misconception on marriage. Fifthly, with her consent, when at the time of giving such consent, by reason of unsoundness of mind or intoxication or the administration by him, personally or through another, of any stupefying or unwholesome substance, she is unable to understand the nature and consequences of that which to which she gives consent. So basically, intoxication, drugs, alcohol, that kind of thing.
You spike someone's drink or stuff like that.
Date rape falls under fifthly. Sixth,
Yes.
with or without her consent when she is under 18 years of age. So that's an absolute bar. With or without her consent under the age of 18. 18 is now what the law is today. It used to be 16. Right? Which is one of those things that does bother me with a different argument. When she is unable to communicate consent. Right? A woman is sleeping. You have sex. She is unable to communicate consent.
मगर इसमें फिर वो भी प्रॉब्लम आएगी ना, क्योंकि इंडिया में यूनिफॉर्म सिविल कोड नहीं है. देन वी विल हैव दैट वियर्ड केस ऑफ अदर रिलीजन्स कंसीडरिंग मैरिज एट अ डिफरेंट एज.
That is not an issue right now, right? That is not. See, I know what you're trying to say, and it arises. We'll see when those cases arise, because Abhi to you don't even have the marital rape exemption, so I don't even know the law, and I know it arises mostly in the case of underage girls. Sixthly, with or without a consent when she's under 18 years of age. In a lot of in a few judgments under personal Islamic law, sex with a 16-year-old or a 17-year-old has been held to be not rape, not statutory rape, because he ends up marrying her.
Yeah, that's so messed up.
It is messed up. It's another piece of religious arbitrage.
Oh, it's just disgusting.
Right? Consent means, I'm going to skip explanation 1. Explanation 2 is consent means an unequivocal voluntary agreement when the woman by words, gestures, or any form of verbal or non-verbal communication communicates willingness to participate in the specific sexual act, provided that a woman who does not physically resist to the act of penetration shall not, by reason only of that fact, be regarded as consenting to the sexual activity. You don't need to fight and kick and scratch to show that you did not consent. Right? But you, as much as this rule can exist, the idea is generally, it is inevitable that in criminal trial cases, this is what arises, that you could have raised an issue and expressed your absence of consent far more vehemently than you claim to have, because in the absence of that evidence, I can't really convict. And that is why these cases become a he said, she said kind of proposition. And there's very rarely good evidence to convict. And so you have Supreme Court judgments that say you can convict solely on the prosecutrix's own testimony. That is not the kind of evidentiary standard that exists in any other law.
Yeah, I just see so many problems with conviction and evidence in rape in general. Marital rape, to bhai, best of
This is
luck.
why there is no country in the world where conviction rates are high.
Yeah, it's just
All right,
impossible.
so I'm going to come to 370 exception 1, a medical procedure or intervention shall not constitute rape. So
Mm.
OBGYNs don't need to worry.
Mm.
Sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15 years of age, is not rape. This is the thing we're discussing today. Now, the punishment for rape.
That's so
Whoever except in the case of, sorry, whoever except, it's not discussing. This is the way rape is defined. Many places in the world. Ours is in fact detailed and tries to cover most concepts. It's an unholy situation that you have to deal with. I used to have a criminal who basically refused to teach us law properly because he was just too shy. he couldn't in a classroom full of young adults speak about rape without literally melting. We have to deal with these issues. For rape, whoever except in the case provided for in section 2 commits rape shall be punished with rigorous imprisonment of either description or term which shall not be less than 7 years, but which may extend to imprisonment for life and shall also be liable to fine. Categories that are set out in 376(2), right, of the kind of situations where you are in custody of a person, what is called as having control over a person through lawful means, and because of that control you are able to, and that creates a situation of trust between the victim and you violate that trust, right? So I'll read those out. Whoever being a police officer commits rape within the limits of the police station to which the police officer is appointed, or in the premises of any station house, or on a woman in such police officer's custody or in the custody of a police officer subordinate to such police officer, um, or being a public servant commits rape on a woman in such public servant's custody, or being a member of the armed forces deployed in the area by central or state government commits rape in such area, or being the, by the way, this one is exempted by AFSPA. Being the management of the staff of a jail, remand home, or other place of custody established by or under any law for the time being in force, or if a woman's or children's institution commits rape on any inmate of such jail, remand home, place, or institution, or being on the management of the staff of a hospital commits rape, being a relative, guardian, or teacher commits rape during communal sectarian violence, commits rape on a woman knowing her to be pregnant, or commits rape knowing when on a woman she is under 16 years of age, commits rape on a woman incapable of giving consent, so on and so forth. Shall be punished with rigorous imprisonment for a term which shall not be less than 10 years. पहले 7 था, इन केसेस में 10 साल मिनिमम. ठीक है, इनको हम ज्यादा सीरियस मानते हैं. Then there were certain additions made because of recommendations in the Verma Committee report, which are punishment for causing death or resulting in persistent vegetative state of the victim. And the difference that they have done here is they have imposed the death penalty here. We had opposed the death penalty in
Just to remind people, Verma Committee report was 2012, and this was
13,
like
just
that
after
gigantic.
Nirbhaya. The Nirbhaya is December 2012. The report is submitted in January 2013, and these changes are made in 2013, 2014. Right? Sexual intercourse by husband upon his wife during separation. This is very important for our discussion. Keep this in mind. Right? You remember all those English judgments that I showed to you, that there is when cohabitation is breached, now the court is willing to say that that is rape by itself. Whoever has sexual intercourse with his own wife who is living separately, please note the word living separately. You're very careful about this. Not judicially separated, but living separately. Whether under a decree of separation or otherwise without her consent, shall be punished with imprisonment of either description for a term which shall not be less than 2 years, but which may extend to 7 years, and shall also be liable to fine. Now see, the punishment has changed. So this value judgment is made even in the case of a judicial separation, or not even a judicial separation, but a normal separation. What would happen is that if a judicial separation exists, then it will go up to 7 years. because then there is a clarity that that consent had been withdrawn. But if it is only her living separately, then it is 2 years. If there is great conveyance of the fact that great evidence on the conveyance of the fact that that consent no longer existed, it might be somewhere between that 2 to 7 range. Right? But 376B is a very specific circumstance relating to marital rape. Right? It is that one exception. In 376B, the state of marriage exists. Right? But what makes it easier to prosecute is that her moving away, living separately, creates an easier evidentiary standard. Because you were correct in pointing out there seems to be a lot of evidentiary problems that will arise. Right? And that is the main plinth of the argument against the petitioners in the Delhi High Court. The short answer to this by Colin Gonsalves has been, let the trial courts deal with it when they deal with it. They'll figure out evidence. Okay. But this is 376B shows to you that there is a different kind of circumstance in which.
Yeah, but just to add, I mean, the evidence would be the same now. What is used as an evidence in the case of a rape in general?
Sorry?
एविडेंस तो वही होगी ना जो रेप में एविडेंस होती है, वही मैरिटल रेप में होगी, और क्या होगा?
To the fact of whether or not rape has occurred. Right? To the fact or not whether rape has occurred. But to the breach of the marital relationship, the fact of living separately first arises. Right? This is an exception to actually 376B, as I see it, is a separate offense, but it is enacted because of the problem created by exception 2 on marital rape. Right, 376C is sexual intercourse by a person in authority, and 376D is gang rape. Those are not material to our discussion today. But I wanted to show to you that there are certain distinctions drawn. Now, can you pull up, I'd asked you, Kushal, to pull up 114A of the Evidence Act.
Yeah, I'll pull it up. This is it here. They just have one. A, B, C, D, E, G. पता नहीं क्या क्या clauses हैं. Presumption as to absence of consent in certain prosecutions for rape.
Right. So there's a presumption that consent does not arise at all in these cases. In a prosecution for rape under clause A, clause B, clause C, clause D, E, K, L, M, or N of section 2 of 376 of the Indian Penal Code, where sexual intercourse by the accused is proved, and the question is whether it was without the consent of the woman alleged to have been raped, and such woman states that her evidence before the court that she did not consent, the court shall presume that she did not consent. Right? So this puts the onus back on the accused. But which are these cases? Which are these cases we're looking at? Can you come back to 376 again? I know it's a bit inconvenient, but you need to come back to 376.
I'll do that.
Sorry, I think there's a... Can you come back to 376-2 again?
Yeah.
Right?
This one, right?
Go to 2. I had read out these in general. Sorry? This is it.
This is 2, right on the screen.
This is fine. I had read out all of these in general because these were very specific kinds of circumstances and cases where the nature of the relationship between the two individuals concerned would establish that rape does not exist. That there is no sexual expectation. And because there is no sexual expectation, Parliament is more comfortable in saying that we could now have a presumption against the consent being granted in these cases. Right? That is not to say that because the presumption is made, the presumption cannot be rebutted. Every presumption is by definition rebuttable. You can lead evidence. So let's take just an example. That a police officer commits rape within the police station to which such police officer is appointed. A police officer is there with a woman. She is an accused in a case, but for whatever reason, or she is a witness in a case. She is present in the station. Things happen between them. They want to get it on. They get it on. Right? She later places a charge against him. He can establish that there were relations between us. There was evidence that there are relations between us that did not altogether obviate the likelihood of having engaged in consensual sex in that police station on that day. Just as an example, to show that the presumption is rebuttable, right? But the problem that happens in the larger argument is people start saying, well, and go back again to what I was saying, that the worry is that a new statute is being created. Now, 114A exists, and it makes certain presumptions as to consent and obviates consent in certain circumstances. So, therefore, at least at the very least, the Indian law of rape, statutory law of rape, has this modulation possible, right? So you have 375, which is a main definitional section, but 376 that creates new categories. 376(2) creates several independent categories. 376(b), C, and D create independent categories. And we look at severity separately. Some are punished higher, some are punished lower. Right? So if Parliament were, if a court were to simply strike down exception 2 and say the exemption from marital rape does no longer exist, it is in fact legislating, because it is making a value-based choice that marital rape stands at parity with all those kinds of rape that fit under only 375. That's, I mean, I haven't followed this beyond, some of the Twitter feed of Live Law, etc. I hope this is the way the argument is presented, because this is the main question that arises now, right? And that is not to say that nobody is appalled by the idea of marital rape. But are you now stepping into a domain where you're precluding the way Parliament would deal with it? And what does the central government do? The central government comes to court and files an affidavit and repeatedly tries to file it even earlier, saying, look, we are comprehensively dealing with not just this, we are dealing with a comprehensive amendment of criminal laws per se. Now, let me bring you back to an old podcast we have done where Aarti was also present. You remember that one where I had explained the criminal procedure relating to
IPC का introduction दिया था.
CRPC.
CRPC.
Right? What did I explain there? Two very important concepts: cognizable, non-bailable. 376, 375 are cognizable, non-bailable. If you strike down the law of rape today, the exception today, you have created a cognizable, non-bailable situation, and this is an allegation of rape. Men will have to be arrested straight away. Right? The short answer to that is, why shouldn't they be, if they're committing rape in a marriage? But the problem that arises is that evidentiary issue.
Yeah, and misuse of the law is also there.
There is a natural separation between the two parties, right? Like all those categories in 376 too. The prevalence of, say, semen stains, the prevalence of, say, injury marks, timing, meeting, all of those things help to establish that this is the man who did it. Right? But in marriage, the expectation is that this is the man who has been sexually active. So where is the defense then? Right? So you couldn't use something like 114A in the case of marital rape and say, we're going to assume the absence of consent. Because the state of sexual activity between the two is a natural state now. Please note, I'm saying sexual activity, not rape. The state of sexual activity between the two is a natural state now. So you can't...
Sexual activity would be consensual.
Yeah. So you cannot impose 114A kind of removal of the assumption of consent in this kind of case.
Got it.
All right. Now you don't do that. If you don't do that, now you end up with a situation where this man and this woman are generally expected to have sex, habitually have sex with each other. No problem at all with that. And let's assume there is no physical violence, there is no other statement, there is no admission, there is nothing. How do you prove it? And that
I
has been
just
the
this is a
and
dead
that
end, I
has been
think,
the
this subject.
experience all over the world. All over the world, that has been the experience. See, not all in India, again, I come back to that old podcast, because it is cognizable, non bailable. Arrest will happen and a charge sheet has to be filed and a trial has to happen. Closure reports are rarely accepted. Whereas abroad, in whether it be Australia, the UK, or the US, the system is you first take it to the prosecutors and you ask them, do we have enough evidence to proceed?
Hmm.
Right? And then what are the consequences to the marital relationship? If you make an allegation of rape and fail to prove it, does that mean that a charge of cruelty also cannot lie? That you've established that cruelty never existed or sexual violence never existed?
Hmm.
So there are problems that all of these issues together, this is why center comes around and says we need to pass a law. But the message that needs to go to the center is quite clear. You cannot allow this exception to continue. You can do it by parliamentary law now. And this is the message the court is giving. You can do it by parliamentary law. Or we are going to bloody well do this for you. And when they do it, it is going to be a bit of an elephant's foot approach, because exception 2 will fall and there are no other changes to CRPC, there are no other changes to consent issues under 114A, and the next thing you know, the moment a charge is placed, men are being arrested. And if I'm just going to extrapolate, because I know there will be a lot of false cases, there have been a lot of false cases under 498A, there have been a lot of false cases under DV, and when that starts happening, eventually the efficacy of that allegation will erode. And we're back to square one. We're back to a situation where theoretically you will have an offense called marital rape, but practically no one's going to enforce it.
Hmm.
So I am quite clear, and I wanted to actually write exactly in this vein, that Parliament and the central government have put the court in a very difficult position. And they need to take a position now and alter this situation, pass the necessary legislative changes so that everything gets accommodated. Possibly, you may consider that if a rape charge is levied by a woman against a man, the first thing that needs to happen is a judicial separation, an automatic judicial separation. So you're not in the same home. But because it is in a marital circumstance that rape has occurred, arrest will have to be for a limited period of time, only for the purpose of investigation. You can have a police custody, but you needn't have a judicial custody for it. If you remember those two concepts, police custody can only last for 15 days in total. That allows the police to have control over the accused and investigate him. Judicial custody is when you're sent to Tihar or Arthur jail. So no judicial custody, but you can have police custody. So these kind
मैं
of
तो फिर
modulations are things that the central government has to now consider and bring into force, because if they don't do it, I don't think there is any good argument to say that, other than the ones that I've shown to you, other than deference to parliament, etc., where once the Delhi High Court strikes this down, the floodgates are going to open. And that responsibility, in my view, will not be on the Delhi High Court. That responsibility will be with the central government and parliament.
so let me understand this. You are saying that this needs a completely new law, first of all, because of
It needs a
the
separate
legal,
code.
yeah,
Marital rape, I
separate
think, needs
code.
a separate code.
Yeah, and to create that code, we might have to amend certain codes currently in our IPC to deal with this
Certain
new.
sections in the IPC, certain sections possibly in the CRPC, maybe some in the Evidence Act.
Okay, so that's all. But the biggest problem I
And
foresee
court
in a
can't do that. Court can't do that.
yeah, I get it. That has to be through the legislature. The biggest problem I see in a society like ours, and I'm not making a legal point, is that this is thinking out loud. जब तुमने बोला ये सेपरेट करेंगे यार, हमारे समाज में अभी तो जाके इनहेरिटेंस औरतों को मिली है, धीरे धीरे उनका उनके पैर स्टेबल हो रहे हैं. कितनी तो औरतें होंगी जिनको कुछ इनहेरिटेंस नहीं मिलती है, उन दे आर टोटली डिपेंडेंट ऑन द हस्बैंड, कि वो हस्बैंड के वहाँ पे ही हैं. जैसे एक हमारे समाज में ये सोच होती है कि तू गई अब तू पराई हो गई. अभी क्या पता नहीं वियर्ड किस्म का लॉजिक है ये, घटिया. मगर प्रॉब्लम ये है कि इफ अ वुमन डिमांड सेपरेशन, यार इंडिया में तो घर कहाँ है, ये होगा कैसे?
He will have to leave. ये domestic violence में हो चुका है पहले. He will have to leave.
अच्छा, वो बाहर निकलता है और औरत घर में रहती है. ठीक है, फिर
And
ठीक
he
है.
pays for that home, he pays for the maintenance in that point in time. See, these are all very complex things. All of this can only be done by Parliament.
Yeah, honestly, if you ask my opinion, because we'll have to wrap it up also, I think not only does the parliament need to do it, I think this has to be a massive social movement where, aaj bhi, whether we like it or not, most divorce cases in India are not settled by courts. They're settled by, community arbitrators. Like, I'll give you an example. Like in Bombay, because my exposure to the Gujarati community and the Kachi community is far more than the Punjabi community. So what happens in these communities is they have elders on both sides. In fact, their rule is that you pick the elders whom both sides trust. They sit down and they settle the case. We don't want to go in the courts because courts में जाएंगे तो गंदी होने वाला है. And I think, I know a few friends who have gone through this route, and the woman has actually received a proper compensation too. Our point is, in a country like India, what are we going to do with this? This is just the Wild West, I feel.
Yeah, you talk about India. I was reading all of that to you about the UK. It's the same in the UK, but it's not like it's different. But I'll tell you what changes. And this was a very interesting survey that I read. 65 plus people above the age of 65 in the UK, around 70 to 72% didn't quite understand what marital rape meant. When is it rape? When it is not? When it isn't? But more than 80 odd percent of 16 to 24-year-olds did. Right? So the younger generation understands better. But that's also possible because the 16 to 24-year-olds aren't really married yet. So
Yeah.
they haven't got into that consent situation.
I was immediately going to tell you कि उनकी शादी कहाँ हुई है, तो
we have these standing jokes about sexual relations in marriages after a certain period of years being fairly perfunctory. And these jokes are supposed to be funny jokes about marriage. Whether you find them funny or not is not the point. The point is they tend to indicate a certain sexual stagnancy within marital relations. This is also borne out by psychological studies, psychiatric studies. And what happens is that you are possibly having sex out of a sense of obligation or a sense of, pursuit of trying to rekindle the passion or whatever it may be. Are those situations of not consent? See, these are all tricky things.
No, I totally agree with you. That to legislate something as tricky as this, it's very hard. It is so
It is very
hard. There are couples who are into weird things. What are you going to do there? It is what it is.
More than that, even the bench of the Delhi High Court, it's a 2-judge bench. On first sight, it is looking fairly equally divided. And look, my purpose today, I hope you understand in the later part of this podcast, I have always said the problem is the theory of why marital rape exemption exists simply cannot be accepted. Right? But the practicality of how it is to be enforced is so difficult.
I 100% agree with you. In fact,
and the
after hearing you,
short evidence of that is whether it is Australia, the UK, or various states of the US, less than 1 to 2% of all allegations of marital rape actually make it to trial. And an even minuscule amount actually amount to punishment.
Yeah, so in Australia, I guess Nanika just shared this with me. So I guess one case in Australia is this one: jury rejects scorned woman defense in rare marital rape conviction. I don't know what this case is, so I'm not going to...
Let me draw out certain categories. Okay, there are 3 categories of rape typically understood. One is battered rape, which is where the offense of battery also occurs, which is really you're physically thrashing someone as well. Even in a marital rape scenario, a battered rape gives you a higher likelihood of a conviction. The second is a forced rape, where the amount of force used is just enough to effect the rape, but it may not leave substantial bodily scars and substantial bodily injuries to establish the rape itself. The third is where there is no evidence whatsoever.
Yeah, what do you do then?
That is why these circumstances are so difficult to understand and prosecute.
Right? Let alone marital rape, even regular, matlab jo outside the marriage rapes hote hain.
Yeah, but there is a difference there, boss. One of the questions, this is why I was reading 114A and 376 to you. one of the questions that arises, the nature of the relationship that we have, there is no reason for us to be having sex, which disappears in a marital relationship. That is why Justice Harishankar is very correctly asking, but what about the nature of marriage? The nature of marriage changes things. Everybody, what is the argument? The Article 14 argument being raised is even a sex worker, has the right to claim rape, but a wife does not. It's a very compelling and emotional argument at first glance, right? But he says a sexual worker can retract consent in a way in which you cannot establish with a marital relationship.
There are no good answers.
There are
Honestly, I don't know.
no good answers.
The,
There are no good answers. And
live
this is
viewer.
the larger problem that what it will lead to is that when you make the allegation, the marriage is dead. Right? So you simply can't continue to remain married after. The marriage is dead at that point. And this is the thing that's worrying a lot of people. I generally don't think that it will be as broad-based or as common as people think. But we also can't just sweep it under the carpet. So that's why I would always urge Parliament has to get together and sort this out.
Yeah, and just before we close, I just want to,
And let them,
because
if they want to sort it out on the negative, let them sort it out on the negative. Let them turn around and say, sorry, we reject everything. You cannot hold this to be unconstitutional. We are willing to fight this in the Supreme Court. Whatever basis of judgment you provide, we're going to erase that basis also and say marital rape will forever remain an exception in India. If you want to do it that way, you do it that way. But you've got to now intervene and deal with this. And really, the only way to deal with it is to accept that marital rape is a reality. It is a substantial reality. And that marital rape is not reported. For those statistics you were reading at the top of the podcast, it is not reported as much because there is no basis of the reportage. What are you going to report when there is nothing to do? When you report this, you say this, then what? Nothing.
Yeah.
Right? You have to accept this reality. You have to now legislate intelligently and sensitively about it. And I promise you, Kushal, if they do all of that, even then, 10 years later, you and I are going to be sitting and talking about how this whole law is entirely failed.
True.
Because it has failed all over the world.
Yeah.
This is a very sad and harsh, chastening reality.
Yeah. I mean, like a live viewer just wrote this. Depressing podcast, Kushal, no solution in sight. So हमारी क्या गलती है, हम कुछ नहीं कर सकते. Sometimes there are no solutions. Look, we'll wrap today's discussion up because we have depressed people enough.
No questions.
No, they were, but most of them were incorporated in your answers. Jo questions say it were, most of the questions were about the evidence, and you have already answered it. Then they were about the exceptions. You covered it in the law. Now, only one question, I will answer it and end. There is this argument, which is the base level. I don't want to use the, I don't know, the traditionalist or the conservative argument that, okay. So somebody has said, why are Indian men so insecure about laws relating to violence against women? And seal it or okay. So I'll just state it out. Oh, if we do this, divorces will happen, society will collapse, blah 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 blah. First of all, these laws exist in many countries. Divorce rates did not go particular. There is no study indicating that after marital rape laws were enacted, suddenly divorce rates spiked through the roof in any of these countries. So first of all,
Absolutely.
that's there is a
But
misnomer.
I have a simpler first principles answer to this, boss. If you are treating your wife like this, let you be divorced first. Why should you be in a marriage? Learn to be
And my second answer is that what is this? So a particular person, man or woman, it doesn't matter, has to be subjugated ad infinitum because you need to save the institution of marriage, has to be the worst argument I've ever heard in my life.
Okay, but let me play devil's advocate to this. It is an indisputable fact that whether it is charges of cruelty or domestic violence, they have been used tactically to elevate the quantum of settlement in a divorce.
That I know. It is
And
happening
once
in
that
India.
becomes a charge of rape, especially with the non-bailable and cognizable element to it, that the scale goes to a different position.
So the law should take care of things like this, where you successfully prove that this charge was false. The fine on the person putting this accusation would act as a deterrent too. So
Not a
I don't
fine.
know.
They're in fact going further. The one of the high courts, or was it the Supreme Court, just yesterday or today, I read a judgment, or just read fleetingly a mention. Sorry, not read the judgment, but read fleetingly a mention of it on Live Law or on Bar and Bench, talking about how it was established in that case that a false rape case has been filed, and the court is like, "This we are not going to let go of this time.
Hmm.
We're not going to let go of it this time." Otherwise, when all of these laws were being enacted back then, 498A or any of these, parliamentarians got up and said, forget it, we are not going to create any rule that for a false case you will be imprisoned.
And just to, as if a false murder case is fine but a false marital rape case is not fine. मतलब आपके ऊपर अगर कोई false murder का charge
Kushal,
लगा देगा आपको चलेगा क्या?
murder cases are harder to levy a charge. A false murder case is much harder to levy a charge.
अरे वो पॉइंट वो नहीं है यार, फॉल्स कोई भी केस हो, फॉल्स चार्जेस आर फॉल्स चार्जेस ना, दैट्स माय होल
Yeah, but
पॉइंट.
there are very few.
ये जो
See, you can have that argument is that you can have abuse of any law, and the possibility of abuse is no basis for establishing constitutionality one way or another. That's an indisputable proposition. But because sexual intercourse is a natural circumstance within a marriage, the fear of the fear and probability rises more in marital relations. I mean, I'm
don't
trying to
get
do my
married.
best to
If
present
people,
arguments on both sides.
if people have a problem with this, they can move to Pakistan where this law will never come, first of all. Or they can just
But
not get
that's
married.
not a feasible reality, right? I mean, we can't now have a liberal version of go to Pakistan here. I mean, we have had enough of this
अरे
go
देयर
to
हैज टू
Pakistan.
बी. अरे मजा आता है ऐसे बोल के लोगों को, बिकॉज इट्स अ स्टूपिड आर्गुमेंट दैट मीन्स फॉर योर स्टूपिड larger narrative of the, and who the hell are you to decide for the entire society here? You don't want to, don't. And I don't know. I think this has to come. How it will come, I don't know. I personally think this law will be a failure even after fixing the problem. I
That's
think
the
this
fear.
law will be a failure because it has a conceptual problem. It has a conceptual problem. That's why this law will be a failure. But it still has to go through it. The debates need to happen, and and all those argo, marriage is a spiritual bond according to my religious view. ठीक है भाई, तुम spiritual bond कर लो,
Hey,
मगर
and
even
if
the
you
spirit.
don't enact the law, right, you don't go through the rigor of various judgments dealing with different kinds of evidentiary situations. You don't go with the rigor of various situations of rebuttal, of kinds and different natures of allegation. If you don't go through that experience, you can't start making smaller categories and more defined categories. Let at least some people get justice. If not, we understand everybody won't, but let at least some people get justice.
Mhm. I agree with you. I
This
agree
is
with you
why
in that.
I wanted to. This is why I wanted to read all of that theory that I was reading in the early part. Because the problem is, those are the only kinds of justifications that establish this exception, right? So again, I just want to end with this. In theory, indefensible. In practice, inoperative. We are so badly stuck.
Yeah. And to all these people who have a problem with marital rape, these are the same arguments the Muslim community gives for nikah halala and many other things. This is the same mindset. Every time society will collapse, this is our way, this is our religion. But too bad, your ideas suck. And
That's it.
society keeps moving
That's it.
forward.
That's it.
Yeah. Too bad, your ideas suck. And society will move forward with you, without you, in spite of you. And on that wonderful note, where we have not given any answer, we will close today's podcast. As always, Nikhil, pleasure talking to you. आज तूने depression देने का काम तूने किया, मैंने नहीं, तो तेरी गलती.
Thanks so much. I can only relate what reality is, and as I see it and understand it, बाकी तो जो है सो है.
Great. So, guys, please go and follow Nikhil on Twitter. His Twitter handle is right there in the description of the podcast. It doesn't matter if you're listening to the audio version or the video version. And if you like what I do over here, I do a very good job at depressing you sometimes, like I did today. Please support the podcast. Please support it on YouTube or on Patreon or by UPI or by the merch. You can subscribe to the channel, like the video. I will see you next week with another interesting guest. Until then, namaste. Take care. Bye.